What is the 72-hour rule? Do Guyanese have a right to have their personal liberty protected? How is the 72-hour rule applied? If the 72-hour rule is applied, can you get bail? Should the 72-hour rule be used in this public health crisis caused by COVID-19? Stay tuned to find out. My fellow Guyanese, my name is Brendan Glassford and you are tuned in to Clarity, where we provide clarity on legal issues that you have questions about. Before we begin, allow me to say this is an educational discussion. It is not legal advice, nor is it a substitute for legal advice. Now with that out of the way, let's address the issues that you have questions about. So within the bowels of our constitution, there lies the 72-hour rule. Now what the 72-hour rule says is that if a person is arrested or detained for one, the purpose of bringing them to court in the execution of a court order, or if they are detained upon a reasonable suspicion of either having committed a criminal offense or about to commit a criminal offense, they can be held for 72 hours. If for any of the two purposes I stated before, they are not released, they can be held for 72 hours. And at the end of that 72 hours, they must either be brought to court or the police may apply for an extension of time to hold them further. Now, the police must apply to the court for an extension of time. So in essence, the 72-hour rule allows the police to hold a person for 72 hours before they have to charge and take that person to court, release that person, or apply for an extension of time. So I know those of you who may be familiar with the law or the Constitution may be wondering, so what about my right to personal liberty? Well, as it turns out, the 72-hour rule is contained in one of the sub-articles to 139, which gives the right to personal liberty. Now, as I say, and as I will continue to say, no constitutional right is absolute. Although Article 139(1) of the Constitution gives a guarantee that you have a right to personal liberty, those are not without exception. And one of those exceptions is, of course, the sub-article 4, which gives the police the power to hold you for 72 hours. Now, I know this may give you little comfort, but the next sub-article, which is 139(5), gives a person who has been unlawfully detained, such as by the police, under the 72-hour rule, can sue the police for that unlawful detention. So where the problem with the 72-hour rule really shows itself is where you have committed an offense for which you should get bail. Now, because the 72-hour rule says any criminal offense, it does not distinguish between minor and serious criminal offenses. Conceivably, if the police wanted to, they could hold you 72 hours for committing something like a breach of the peace or threatening language or threatening behavior, which of course are misdemeanor offenses and very small, or something like not being able to produce your driver's license. So because the 72-hour rule does not specify that you can only be held for 72 hours for serious offenses, you can be held for something minor. So another important concept to understand in relation to the 72-hour rule is bail. Now, what bail is basically security for your appearance in court. In the Guyanese legal system, there are 3 levels of bail. What is colloquially known as station bail, which we will zero in on in a bit. There is also Pre-trial bail, which means when you appear before a court on the first occasion, you have the entitlement, once that offense is bailable, to make an application for bail. And if you have been convicted, there's a third level of bail called bail pending appeal. Okay, so where a person has been arrested with or without warrant and is in the custody of the police, there is a principle colloquially known as station bail, which is that that person is supposed to be brought before the court as soon as practicable. So if you are arrested and then taken to court within hours, there is no need for bail because the court will deal with bail. However, if there is a need for you to wait for a court date, a police officer may inquire into the matter, and once in their opinion it is not a serious offense, they may give you bail, which means you enter a recognizance, you sign a piece of paper saying that you will appear in court on the date given to you. Now, this may be done by the police with or without any form of security, such as money. So what the 72-hour rule in fact does is it interferes with this process of the police giving you bail. Because there are no guidelines, they may feel they need to hold you for 72 hours based on whatever reasoning they come up with in their discretion. So I would say under normal circumstances, people would not want to be held by the Guyana police force. Now, aside from the alleged conditions under which people are held, generally people do not want to be held by the police force if they can be given a summons or a ticket, depending on the offense. In the case of a public health crisis like COVID-19, being held by the police could be a death sentence. Now, as most people know, preventing yourself from getting COVID-19 has a lot to do with physical and social distancing. Being in such close proximity to police and possibly other prisoners, and especially if you have other underlying conditions and get COVID-19, it could possibly be the death of you. So what the Guyana police force should consider doing at this time is suspending holding people all but for the most serious of offenses. So holding a person in custody for criminal offense is just an interim stage until you get them to court. So in this COVID-19 health crisis, the Guyana police force should definitely consider suspending use of the 72-hour rule and considering minimal contact procedures for getting people to court, such as tickets where traffic offenses are concerned and summons where other offenses are concerned. Persons should only be held in custody for long periods of time where it is absolutely necessary. Now, one thing that has to be considered is at this point in time, the court has given several notices saying that only urgent matters are to go to court. So definitely arresting people under all but the most dire circumstances should be suspended, and procedures such as summons and tickets should be put in place. So in the long term, other than the COVID-19 public health crisis, this is definitely a rule in the Constitution that should be reformed. It should not be applicable to every criminal offense. It should definitely not be applicable to offenses an individual is entitled to bail. It should only be used in cases where the protection of the public is necessary and where serious offenses are concerned. I hope we've given you clarity on these legal issues. Until next time, take care.